Lordship.
Any mentioning?
Lordship.
Yes.
Lordship, may I be permitted to mention an application GA 273 of 2025? This is an application that I had taken out as an intervener for recalling of your Lordship's order passed on 13th of January 2025 in CS number 970.
Matter has been assigned to this court, I suppose.
Lordship.
এটা দেখো অ্যাসাইনমেন্ট হয়েছে মনে হচ্ছে।
No, your Lordship. Lordship was taking up this matter when your Lordship had the determination to pass the order on 13th of January. So this matter was listed before Honorable Justice Bishwarup
This
Chaudhary.
matter has been assigned to this court. একটু ফাইন্ড আউট করো। হ্যাঁ,
Lordship.
দিয়ে ডেট দেবে। দেখেন দিন, প্রবাবলি ও পাঠিয়েছে ফাইল।
Lordship, I have also annexed the order, Lordship.
অঞ্জনবাবু কত? ও,
Lordship, I'm
7th বা 14th যে কোনো থার্সডেতে আমি নেব, ঠিক আছে? না, দেখে নেবে কবে অরিজিনাল সাইডে অন্যান্য ম্যাটার্স গুলো আসছে, সেদিন লিস্ট করে দেবো। Will come up in the coming week or week thereafter.
grateful, Your Lord.
Original site for judgment, item number 1.
Who is for the bank?
I am for the bank in this matter, madam.
Suit is dismissed on contest. No order as to cost. Plaintiff
Much
company is granted liberty to withdraw the amount deposited along with accrued interest with the defendant bank pursuant to the order of this court dated 15 June 2011. That fixed deposit you get back that. Thank you. Party is on chamber. List up.
1 and 3 item number. Item number 1 and 3.
1 and 3.
Sir, this is the affidavit of service in item number 3.
1. Item number 1.
Item number 1, my lord, if kindly takes up item number 3 first, because item number 3 is the retiring urgencies in item number 3. I will tell your lordship, in same proceeding, 2 orders are being challenged in 1 and 3. 1 in item number 1, that is the former order in the same proceeding, and item number 3 is the subsequent order. My lord kindly takes up item number 3 first, then
Item number 3 because I am not appearing in.
Then item number 3 is for the state.
Mr. Lolit Mohan Mahato is for the state, my lord. I have served notice, my lord. I can give it. I have served notice of upgradation. My lord, I will give it to you, lord.
Item number 1, your lordship kindly takes first.
Okay. In the morning, who appeared for the Pradhan? Jila Parishad. You are for the state.
We are for the state and my undertaking is appearing on behalf of the private respondent.
In 1. 1 and 3. And you appeared for private respondent in the morning? Okay. Okay.
But if you
Mr. Chatterjee was not there. Oh. Acha. Okay. Okay.
your lordship kindly state looks at
Affidavit of service in respect of 1, sir.
Item number 1, there was already item number 1, the affidavit of service was already submitted earlier. Because
Okay.
in that matter, my lord will see there was order.
Acha, ठीक है.
That matter was went for
1 is against a demolition notice
order, yes, ma'am.
previously issued.
Previously issued by
3 is subsequent notice issued.
subsequent order. Because 1, my lord, I will tell you, lordship, in a demolition proceeding, in item number 1, the order dated 16/1/2025 was passed in a demolition proceeding. Now, my lord, during pendency of we challenge that order in item number 1, WPA 2357 of 2025. Now, my lord, during pendency of 2357 of 2025, the learned SDO recalls their demolition. Recalls the demolition order and passes a fresh demolition order. And that fresh demolition order is challenged in item number 3.
No.
Now, my lord, my subject to what falls from your lordship, my lord. According to me, my lord, the item number 3 may be heard by your lordship because the order impugned in item number 1 may not be effective because that has already been recalled by the SDO himself. There is a specific order to that effect. To see that, my lord needs to see the item number 3's brief because the subsequent orders are annexed with the item number 3. That is the reason why I was urging my lord to see the item number 3, my lord.
My lord, as a fallout of the order passed by the SDO, which is impugned at page 51, my lord, subsequent orders have been passed by the BDO, my lord, for demolition, which has been fixed today, my lord. If your lordship kindly takes, my lord, straight away your lordship kindly comes, page 54 of
So one has become infructuous.
My lord, may kindly for once takes up item number 3. I will show your lordship one thing, my lord. Then everything will be clear.
the SDO order recall করেছে
Yes.
My lord, page number 68 of item number 3 is brief, my lord.
এই তোমার কাছে অর্ডারটা আছে দেখি
68.
68, yes, my lord. And it's a P9. My lord has got that. My lord, may I read, my lord? Peruse the amendment petition submitted by the petitioner in connection with LR case number 2 of 2024 pertaining to this court, and also peruse the letter submitted by Block Development Officer Ketugram 1, white memo number so and so, dated so and so. On perusal of both, this court is of the opinion that there are some anomalies as observed by the BDO Ketugram 1 block during execution of the order dated 16/1/2025 issued by the court. This order is impugned in item number 1. Hence, to ensure thus justice, this court finds it prudent to call for a rehearing of all the parties, stakeholders pertaining to LR case number 2 of 2024 on 11/3/2025. Leading assistant is directed to serve the notice of rehearing to both the parties of this case, along with BDO Ketugram 1, Block, BL and LRO Ketugram 1, Block and Pradhan J. Kandra GP. Now, my lord, after this, SDO went on proceed for a rehearing. So, my lord, I may not say that the order was completely recalled because the recalled word is not spelled. But today, the demolition testing, which is being done by the BDO, I believe it is on the order impugned before your lordship in item number 3. Because my lord will kindly comes to page number 71. That is the order dated 26/3/2024. In that order, there is a detailed demolition order on which a fresh demolition order is being passed against me. So, my lord, that is the reason why I was urging your lordship to take up item number 3.
Lord, what I have gathered, my lord, demolition order subsists. In continuation to the demolition order which has been passed by the SDO, Subdivision Executive Magistrate, at page number 54 and 55 of your lordship's briefing, item number 1. My lord, in continuation to that order, my lord, another order is passed, my lord, slightly only, my lord, deviation portion, measurement portion has been slightly changed. Order remains same. That order subsists.
Okay.
Illegal construction that has been found by joint inquiry committee, and my lord, upon giving notice to all the stakeholders, they are all present. Demolition order subsists, and my lord, only slight change.
Wait.
Only, my lord, slight change in the, my lord, schedule of demolition portion, my lord. That will your lordship would find at page 71 of the, my lord, second read petition, that is item number 3.
Yes.
And comes to say page 71. Lord, your lordship kindly, fourth paragraph, the sentence starts during measurement. Kindly reads during measurement deviation in construction of the building and observe that excess occupied area as identified are in the northern side 48 feet and 4 inches, southern side 35 feet 2 inches, eastern side is 11 feet and western side is 8 feet 10 inches. This is a joint inquiry report and sketch map annexed. thereafter will submission of the party respective parties.
Hmm.
Will kindly text will page 72. Will peruse the sanction building plan issued by the Pradhan such and such in favor of petitioner, wherein it is clear that the building is supposed to be constructed on plot number 5018 in Moja such and such, but from the joint inquiry report and sketch map submitted by the BDO, it appears that there has been a deviation in construction of the building from the sanctioned building as mentioned in para 3 of this order, and the said deviation part is constructed on plot number 5020. On which no sanction building plan is accorded by the concerned Gram Panchayat. This is very important. Now, in the light of the direction issued by this Honorable High Court in such and such writ petition and also in an mandamus appeal, this court on being satisfied on the modified joint inquiry report so submitted by the BDO Ketugram that the petitioner as per section 23(5) of West Bengal Panchayat Act 1970 read with the West Bengal Panchayat Amendment Act 2017 to demolish the deviated portion of the building in question as mentioned in the modified joint inquiry so submitted by the BDO such and such by memo number such and such, maintaining all safety norms and structural stability of the adjacent building within 20 days from the date of receiving of this order. This block development officer is further directed to demolish the excess deviated portion as mentioned in his report within 7 days and after completion of the period of 20 days in case of non-compliance from the end of the petitioner and recover the cost thereof from the petitioner as a public demand, maintaining all safety norms and structural stability of the adjacent building. So these orders subsist today. And today is the date of the demolition. We do not know whether demolition has taken place or not. In all probability, demolition has taken place.
May I
Started, commenced.
The demolition process has not taken place because why I will tell your lordship, after the matter was mentioned before your lordship, my client informed me that there is a demolition process ongoing. So I personally called the BDO and said that see there is a matter, the honorable judge has been pleased to fix the matter at 2 p.m. Kindly do not take up the demolition process. BDO has been very favorable to me, my lord, and has stopped the demolition process till 3. So the demolition has not taken place. I can submit this on the findings of my client, my lord. Now, my lord, may I start the hearing, my lord, because item number 1 and item number 3 doesn't make any difference because item number 3 only annexure P9 is the extra annexure which your lordship will find, because annexure P8 up to annexure P8 the story is the same in both the items. So if your lordship takes up item number 3, I think, my lord, all the annexes are there, my lord, and the comprehensive hearing can be done subject to what your lordship says. May I start?
Yes. Conclude it.
My lord, may first kindly comes to page number 20 of my writ petition of item number 3. Now, my lord, before I start, my lord, 2 plots of land, my lord, 5018 and 5020. These are the 2 plots of land. 5018 is recorded in the name of the petitioner, and 5020 is recorded in the name of one trust. Now, my lord, in that trust, both petitioner and the private respondent are the members of that trust. However, my lord, when the first allegation of encroachment came from their side, they chose to prefer a title suit before the jurisdictional court. And they alleged that there is an encroachment ongoing, and obviously for that reason, they moved an ad interim application before that court. Now, the temporary injunction application is annexed at page number 20 of the writ petition. The operative, the relevant part is that
enlightened what are the infirmities in the order? What are the infirmities?
Well, kindly comes to page number 22 of the writ petition. Page number
2019. No, these aspects were considered by the writ court in the earlier writ petitions.
Because, my lord, the encroachment, 3 writ petitions, that is,
Then-
my lord.
At that point of time, also the suit was pending.
The suit was pending, and my lord, these aspects,
Now, what is the order passed, which the SDO says that he has complied with the order passed by this court? What are the orders passed in that proceedings?
my lord, in the previous round of writ petitions, my lord.
Yes.
My lord, for that, my lord, may I have your lordship's leave that document was unfortunately This is an order passed in the one of the previous round of litigation.
The private
Again-
is the order
against
passed in the appeal court, my lord.
হ্যাঁ আমাকে একটু বলতে দিন না স্যার, আপনি বলবেন তো। My lord, this is a previous round of writ petition order, my lord. I am serving copy to the other side, my lord. The appeal order is annexed to the writ petition. The single judge order is not annexed, my lord. May I hand over?
Page 41. আছে এই appeal
না না, এটা রিট কোর্টের অর্ডারটা, ওটার অ্যাপিলেটার অর্ডার ওখানে আছে। My lord, in page number 2 of that writ petition, my lord. Now, my lord, first of all, the SDO was of the opinion, since there is an encroachment and encroachment has to be decided by the civil court, SDO didn't act on the matter. So, my lord, the private respondent challenged that order before this honorable court, and this writ court was pleased to pass the order, my lord. My lord, may kindly come to page number 2, third paragraph. In the opinion of the court, the findings, no, my lord, kindly comes to second paragraph. At this juncture, the petitioner wants to improve the case by submitting that the findings of the subdivisional officer was inadequate and incomplete. Apart from coming to the decision with regard to the alleged encroachment, the subdivisional officer was required to initiate proceedings for demolition in terms of section 23(5) of the West Bengal Panchayat Act 1973. Further allegation has now been made that the minimum site spaces which were required to be kept between the two plots of land, namely 5018 and 5020, had not been maintained. In the opinion of the court, the findings of the encroachment by the block development officer and the subdivisional officer can only serve as a supporting evidence in title suit filed by the petitioner, being title suit number so and so. The final decision has to be taken by the civil court. However, the issue as to whether the construction of the respondent number 10 has been made strictly in accordance with the sanction plan and in accordance with the rules will have to be decided by the appropriate authorities at appropriate stages under section 23 of the West Bengal Panchayat Act. The pleadings and record do not reveal that any such plea had ever been taken by the petitioner. Admittedly, there is a sanction. The finding of encroachment can be put to use by the petitioner in the civil proceeding. If the petitioner now alleges that the plan had been deviated from or adequate site spaces had not been maintained and the building rules has been violated, the same gives rise to a new cause of action. Now, my lord, I pause here for a moment. Now, my lord, kindly sees the new cause of action is that the plan had been deviated from the adequate site spaces have been maintained or whether the building rules have been violated. These two are the
The issues decided by this construction
cause of action, for which the petitioner can always approach the Panchayat authorities in accordance with law. Then the liberty was given to them to file appropriate representation. Now, my lord, this petition, this order, your lordship kindly find this writ petition was preferred by the private respondents in the writ petition, because at that time SDO refused to pass an order on the encroachment because that encroachment was sub judice for the civil court. Now, my lord, we appealed against that order. My lord, will kindly see page number 33 of the item number 3 writ petition.
Operative page is at page 41. দেখো রাখো না তুমি।
Now, my lord, will kindly comes to page number 41. That is the order, my lord, page number 41 on of my writ petition. My lord, in fourth paragraph, my lord, in the aforesaid factual scenario, my lord has got that. In the aforesaid factual scenario, firstly, we find that the order of the learned single judge has been carried out since, my lord, by that time they have submitted the representation, and therefore nothing remains in the submission. Secondly, even on merit, we see no infirmity in the said order. The learned judge has rightly held that the issue of encroachment has to be decided by the civil court in the pending suit. However, the issue as regards construction have been raised by the appellant hearing is deviated from the sanction plan has to be decided by the concerned Panchayat authorities. In fact, such decision has been arrived at by the Panchayat authorities. It is now for the appellant to challenge such decision by the Panchayat authorities in accordance with law without the appropriate forum if so advised. We see no reason to interfere with the order under appeal. We, however, clarify that the finding of encroachment made by the concerned block development officer or the concerned subdivision officer will not be binding in any manner on the learned court, which is in session of title suit number 44 of 2019. The learned court will be at liberty to come to an independent decision in that regard on the basis of materials before the court, observing the principles of natural justice. That is the reason why I was harping on the issue, my lord, that I was pleasing your lordship to take up on the order which was passed by the civil court. Because the civil court refused their injunction on contested or temporary injunction on contested hearing, saying that there is no encroachment, there is no prima facie case in favor of the petitioner, the private respondent for the civil court regarding encroachment. However, my lord, since we are proceeding in this matter, my lord, I will take your lordship now to page number 55 of my writ petition. Now, from this, my lord, from here, my lord, the finding becomes relevant. Now, my lord, this after the appeal court orders comes up, the SDO directs an inquiry. Now, my lord, this was the first inquiry. SDO directs an inquiry. My lord knows the SDO directs the inquiry to the concerned BL and LRO, and BL and LRO to the revenue inspector inquires the matter. Now, my lord, kindly sees, may I please, as per your instruction, my lord has got page number 55.
55, yes.
Page number 55.
number
কি নম্বর আইটেম 55 নম্বর
For your instruction related number.
My lord has got a report of the revenue inspector last time by the revenue.
Yes.
Now, my lord, may I place that? My lord, this is the actual field inquiry report because my lord knows the field inquiry is done by the revenue inspector. Revenue inspector gives the report to the BL and LRO. BL and LRO forwards it to the BDO and BDO to the SDO. Now that that synchronization has been maintained. I will show to your lordship. Now, what the field inquiry report says, my lord, kindly sees. As per your instruction regarding the letter number stated above, demarcation of plot number 5018 and 5020 under Mouza Kandra, jail number 36, had been conducted on 14/1/2025 by the undersigned, along with Amin of this office in presence of Pradhan, so and so, petitioner and defendant of the concerned cases. After thorough measurement on the basis of Hilar map, it appears that a part of plot number 5020 is occupied by the construction predominantly situated on the adjacent plot number 5018. Now, my lord, I say, the measurement of the occupied area is so and so in the north and south and east and west so and so. Now, my lord, I say that this inquiry report goes dehors to the order passed by the Honorable Appeal Court or this learned single judge for that matter.
However, the issue regards construction raised by the applicant in deviation of sanction plan has to be decided.
The issue of encroachment was directed not to be decided. And
But
the
you
revenue
have-
inspector goes up and says that there is an encroachment.
But if there is an encroachment, there is a deviation from the sanction plan.
Encroachment means deviation. But the encroachment, the deviation from the sanction plan, my lord, kindly comes to single judge order for once. Because that order was upheld by the appeal.
No.
Whether I have
Come to
followed-
page 41.
My lord.
However, the issue as regards construction having been raised by appellant herein in deviation of sanction plan has to be decided by the concerned panchayat.
Yes. My lord, but there was at that point of time, my humble submission is that that point was already considered by the appeal court earlier. If that 5018 encroachment at that point of time also there was a deviation of sanction plan then. But that point has already been considered, and the Honorable Appeal Court was pleased to say that no encroachment you will not.
At that point of time, this revenue inspector's report was not there.
The revenue inspector's report
So,
harps on whether
the order does not say that you go on deviating from the sanction plan and get into the adjacent plot.
No, my lord,
Does that endorse? No.
No, my lord, may I?
At the time when you mentioned, I asked you, why are you encroaching into the property of others? You say that, no, there is no such encroachment.
Civil court's finding is that they have no prima facie case. I have not encroached because there is a civil court finding after the temporary injunction order passed by the learned civil court. The temporary injunction order passed by the learned civil court comes
Then
to a finding.
The order passed by this court has been complied to the extent that they have found that there is a deviation in the.
Yes. No, my lord, there is no deviation. Why? Because the side spaces, because the 2 points of deviation has been made clear by the honorable court. Whether I have been in deviation of the open side spaces, my lord, kindly see the private respondent's case was that I have not maintained the side spaces, but the side spaces report is not there. Here the report is of encroachment. Kindly sees the learned single judge order for that matter for once, my lord. Page number 2, my lord. In the opinion of the court, the findings of encroachment by the BDO and the SDO can only serve as supporting evidence in the title suit filed by the petitioner before title suit filed by the petitioner. The final decision has to be taken by the civil court. So, my lord, that finding of encroachment was still there at that point of time when it was impugned before the writ court earlier, my lord. This finding of encroachment was still there, my lord. That is my submission. And my lord, the final decision has to be taken by the civil court. However, the issue as to whether the construction of the respondent number 10 has been
Here is this.
strictly in accordance, my lord, kindly bear with me for a moment. Strictly in accordance with the sanction plan and in accordance with the rules will have to be decided by the appropriate authorities at appropriate stages under section 23. The pleadings and records do not reveal that any such plea has ever been taken by the petitioner. Admittedly, there is a sanction. The finding of encroachment can be put to use by the petitioner in civil proceeding. If the petitioner now alleges that the plan had been deviated from, so my lord, this is the new case of the petitioner. This case is only has to be considered. If the petitioner now alleges that the plan had been deviated from or adequate site spaces had not been maintained, the building rules has been violated. So whether the adequate site spaces has been maintained or not has to be now considered, because there is a sanction and the deviation, finding of deviation was already there when the honorable coordinate bench or the honorable appeal court was in session over the matter. These issues are already prejudged. The BDO, SDO cannot enter into these issues after the honorable court has already passed an order to such effect. The finding of encroachment was already there. It is evident from the order itself, my lord. And this order was affirmed by the appeal court, my lord.
That is what I am saying. If it is affirmed, then there is a court has also directed the authority to take steps if there is a deviation.
Yes. No, my lord. The deviation.
You have a sanction plan that is recorded.
My lord.
You cannot deviate from the sanction plan. The court says that if there is a deviation, the authorities will take steps in accordance with section 23.
With regard to the open site.
Now, what you are submitting is, since the court says that the matter of encroachment is session before the civil court, so SDO should not take any steps. But at the same time, the court also says that if there is a deviation, it should be in accordance with, steps should be taken in accordance with section 23.
My lord, deviation, because the new case which was made out by the learned, because new case they have been made out before the learned single judge is with regard to the open site space. My lord, kindly comes to the page number 3 of the order once of these learned single judge order, which was affirmed by the appeal bench, my lord. Finding of encroachment can be put to use by the petitioner in the civil proceeding if the petitioner now alleges that the plan had been deviated from or adequate site spaces had not been maintained. So, my lord, this is the new cause of action of the petitioner now, because that finding of encroachment has already been judged. That is my submission. So, the adequate site spaces is the only thing that has to be judged now. And my lord, in my humble submission, I will show to your lordship. No, page number 55. There was no finding of non-living of adequate site spaces by me. Only the encroachment finding is there. Kindly cease. Joint field inquiry. Inquiry. Page number 55 of my writ petition. Item number 3. This thing was already challenged earlier. Now, my lord, interestingly, my lord, kindly comes to page number 55. Kindly comes to page there before my
southern side.
kindly comes to page there before, my lord, page number 54.
Fifty-four.
My lord, kindly sees that BL and LRO forwards the report of the revenue inspector to the BDO, concerned BDO. Now, what does BDO reports to the SDO? The page before, my lord, 53, page 53. What does the BDO reports to the SDO, my lord? Kindly see. There lies the conspiracy against me, my lord.
Good area.
As per the order issued by learned subdivision officer Kathua, Puro Vardhaman, by memo number so and so, dated so and so, with reference to WPA 935 of 2024, arising out of MAT case number, my lord. These numbers are all wrong written, my lord. At the Honorable High Court at Calcutta, the undersigned held a joint inquiry involving BLN LRO, Ketugram 1 block and Pradhan so and so in presence of both the parties and or their representatives to assess the deviation of construction of building in question from the sanctioned building plan. The notice of joint inquiry was issued by memo number so and so. Notice was received by the parties. The demarcation of and measurement of plot number 5018 and 5020 under Mousa so and so and jail number so and so has been conducted. After thorough measurement on the basis of LR map, it appears there is a deviation of construction of the building from the sanctioned building plan issued by the Gram Panchayat. This is also to be mentioned that from the field inquiry, it is revealed that Shamul Kumar Datta has not maintained the site spaces while constructing the building in question. Now, my lord, I put a question to myself, my lord. How do BDO arrive to this report, my lord? Because his officer doesn't say so to the BDO. His officer only says that there is an encroachment. His officer never says that I have not left the adequate site space. I have never spelled the term adequate site spaces.
If you get into the site space excess, what is left as site space? Tell me. Common parlance, tell me, here is a construction which has to be undertaken within a particular plot of land.
Right.
4 feet site space has to be given as per, I don't know, it may be 4, 6, whatever. Now the report says that the construction in excess of the occupied area. That means the sanction has been granted for some plot of land. The construction had deviated and gone into the adjacent plot.
My lord.
So you say that still it is within, you say that still it is not deviated.
Why, my lord? Because us, we do not.
Arjun, take his state keyboard.
I don't know.
Yes, Mr. Mahata.
No, my lord, I have not finished my argument.
Finish it. Enough time is given. Others are waiting.
My lord, now my point is that how the adequate site spaces report was not in the report of the revenue inspector.
Okay.
And now, my lord, kindly comes to order impugned. If your lordship wants hear the state first, my lord, then I will use tell this.
No, you complete. Again, we will get reply, then this day will go. The other advocates, they are also waiting. Whatever you have to submit, you submit in short.
My lord, will kindly comes to page number. I am not taking your lordship to the earlier order, my lord. The earlier order is also annexed, but my lord will kindly comes to page number 71. My lord. That is the order impugned. Now, my lord, the second paragraph, the demarcation and measurement of plot number 5018 and 5020 and Mousa Kandra, jail number 36 has been conducted. After thorough measurement of the base on the basis of LR map, it appears that there is a deviation in construction of building in question on the sanctioned building plan issued by the Gram Panchayat. During measurement, deviation in construction of the building is observed and excess occupied areas. Now, it is occupied areas, again, this portion which has already been decided, it has been taken recourse of by the SDO. Excess occupied areas as identified are in the northern side so and so, southern side, eastern side so and so. The learned advocate representing Shri Shamul Kumar Datta submitted that the excess occupied area as mentioned in the report submitted by BDO should be treated as encroachment as not as deviation of the sanctioned building. We have treated this thing. We have said this thing before the SDO, my lord. Now, the learned advocate representing Shri Kartik Chandra Datta submitted that hearing should be held strictly on anomalies observed by BDO during execution of the order dated 16/1/2025. Now, my lord, here is also a story, my lord. Order passed by BDO on 16/1/2025. The court is in session over the matter. Again, the BDO says that there is an anomaly, and again, the SDO passes a new order. Reduce the sanctioned building plan issued by Pradhan Kandra GP in favor of Shamul Kumar Datta, where it is clear that the building is supposed to be constructed on plot number 5018 in Mousa so and so, but from the joint inquiry report and sketch map submitted by the BDO, it appears that there has been deviation in construction of building.
Again, you are reading the same thing. This you have indicated. Any other aspects you want to indicate?
My only argument is that there is no finding with regard to open site spaces by the at the joint at the field inquiry report, and hence it is gone out from the appeal court's order.
My lord, I am not repeating what he has submitted. Only page 41, the division bench.
Yes.
My lord, the last paragraph in the page 41. In the aforesaid factual scenario, firstly, we find that the order of the learned single judge has been carried out and therefore nothing remains in the appeal. Secondly, on merit, we see no infirmity in the order. The learned judge has rightly held that the issue of encroachment has to be decided by the civil court in the pending suit. However, the issue as regard construction having been raised by the appellant herein in deviation from the sanction plan has to be decided by the concerned panchayat authority.
Hmm.
And that has been inquired into from the BLRO part, from the Pradhan, and everything is that the sanction plan has been deviated by encroaching the others plot, and thereby the deviation of the sanction plan. And so, my lord, there is nothing any irregularity or illegality in the order of the subdivision. Well, this is the short and
There is one order of the shut up. That is one of the page number. And not three.
Page number. Well, what is the page number? Justice Sarab's order.
Page number 31.
There is 3, 4, page 31 and 31. They have not stated their feelings about that order, but they are valid. They are lifting the order of the there was no sanction plan at all because our submission and on the last one was in my view action of illegal construction required to be checked by the government just for the sanction. They also made submission about their shoot and others. Justice Sharaf passed this order. Subsequently, this has gone to Justice Amrita Sinha. Amrita Sinha directed to demolish that. They filed an appeal against that order. Appeal court asked us to file a representation, consolidated representation stating all the facts. We stated that. Thereafter, the authority for such challenged it before the honorable court. Justice Shokma Shankar passed this order, of which already has gone through. That has been affirmed by the division bench and also given directions to us as per the division bench direction to the and also that has been considered by the concerned authority, Pradhan, BLRO, PO, all have gone to joint inspection. All of them detected that there is deviation. It's already gone through. I should not reiterate. Thereafter, my lord, SDO passed the order for demolition. Thereafter, they made an application so that the demolition can be motivated as to get complete portion. SDO considered, we have not objected to that. Last order, which has been challenged, only modified order, that is modified. We have not agitated any objection to that. That is one ground. And today is the date of demolition. There is no infirmity of the order, and that has been passed as per the order of this honorable court.
In in read petition number 1, item number 1, where is the order? Order?
They cannot deviated from any state.
The order in view.
Yes. In the 16.1. 16.
54 in item number 1.
Item number 1, my lord. 54, my lord.
My knowledge of
Ultimate paragraph.
he has filed earlier a petition. In this petition, he has not stated anything about security. Well,
My lord, may kindly comes to paragraph number.
however, my lord, I have not Your lordship about that point.
My lord, paragraph number 19 of my writ petition. Of the new writ petition, paragraph number 19, kindly see.
Or might be, he may be stated it. The police have to. That's taken.
Only one reply on law point, my lord.
Why the second order comes? Because at that point of time, there was no joint inspection. Why the second order has been passed?
Upon his application, upon his
Report by the
His application
Our-
particularly, my lord, to protect.
may I submit, my lord?
Okay, Ashun.
Order.
My lord, that is,
One
that
reply
is
law point.
particularly, my lord,
But
to
if today-
protect the
My lord, on
the other part of the, my lord, the
one reply
construction.
on law point. One reply.
How consistent has been given to you?
My lord, only one reply on law point. If today, my lord, the encroachment of 5018 to 5020 is decided by the SDO, and if your lordship subsequently affirms the view so by the SDO, my lord, what is left to be decided by the civil court? May I ask this question to myself, my lord? Because they have already chose first to go before the civil court decide the encroachment. My lord, the civil court suit becomes infructuous by the orders of the SDO and the BT.
That document with me.
My lord, the suit has not been released as per my instruction.
With করে দিই এটা 1 and 3 with করে দিই
may I have your lordship kindly.
These writ petitions are filed for setting aside order dated 16 January 2025 passed by with this one number and passed by together and order dated 26th March 2025 passed by the respondent number 6 subdivisional officer Katwa. The the petitioner আচ্ছা উপরে একটা affidavit সার্ভিস লেখেন 9074 তক কি আছে affidavit on service 3 তে হবে affidavit service filed in WPA 9074 2025 is taken on record. The petitioner contains that one, Obhibhushan Datto purchased a plot of land situated within plot number 5018, jail number 36 under Moja Kandra. And he transferred the said property in favor of Satyabhushan is your father.
Satyabhushan is my father.
Lord,
Yes.
Satyabhushan is your father.
And Satyabhushan Datta is my father, my lord.
Transferred said property in favor of the father of the present petitioner, Satyabhushan Datto, who died intestate in the year 1997. During his lifetime, Obhibhushan Datta executed a deed of trust on 10th September 1986, wherein the petitioner, the private respondent number 11, and their other cousins, six cousins, were trustees and beneficiaries of the trust in respect of property lying and situated within plot number 5020, Mouja Kandra, jail number 36, in the district Bardhaman. আগে পিছনে করে দেবেন, পুলিশ স্টেশনটা আগে দিয়ে দেবেন, পুলিশ স্টেশন কেতুগ্রাম, measuring more or less 6 decimals of land, along with two-storied building, which was given on rent to State Bank of India, Ramji Banpur branch. The private respondent number 11 filed writ petitions alleging of illegal unauthorized construction by the petitioner being WPA 3338 of 2023.
The first petition was of 2019. That it
Right.
Justice Sharaf's petition.
Filed writ petitions being WPA 3389. ওটা হচ্ছে is page 31, no? You indicate 30?
It's 31.
31.
That was the first.
WPA 15382W of 2019. Which was disposed of directing the yes, I find. Pradhan to forward inquiry report along with other relevant documents to the subdivisional officer for taking appropriate steps in accordance with the law. Subsequent thereto, the private respond number 11 also filed writ petitions being 2023 and 24. WPA 3338 of 2023. And
that order was challenged by us in minor will kindly come to page number 35.
order passed in WPA 15382 was challenged in appeal in MAT
1117, page number 35,
2019.
2022, Act 17 of 2022.
Was challenged in appeal
The order is quoted.
in MAT 1117 of 2022. And respondent number 1 writ petitioner was granted liberty to file comprehensive representation regarding his grievance before to the concerned block development officer. and further directed the block development officer to pass reasoned order. হলো। এবারে subsequent thereto the filed WPA, the writ petition being WPA 338 of 2023. Alleging of encroachment and unauthorized construction by the private respondent. By the petitioner, the respondent therein. In the said petition, liberty was granted to the petitioner to file representation, and the authority was directed to dispose of the same in accordance with law upon providing an opportunity hearing to the parties. The order passed in the writ petition, date টা নিয়ে নিন, 13th March 2023 যে অর্ডারটা was appealed against in MAT 757 of 2023. কাজ করুন তো, ওইগুলোতে না অর্ডার্স গুলোকে কোড করে করে চলে যান, তাহলে খুব ডিফিকাল্টি হবে পরে করা। পেজ 29, থার্ড রিট পিটিশনের ওই যে এখানে বলছি, পেজ 29, টোয়েন্টি ফাইভ হলো 29, 25টা জাস্টিস সিনহার অর্ডার, 29টা হচ্ছে অ্যাপিলের অর্ডার। এই যে বলে দিল। হুম হুম, এখানে দাগ দিয়ে দিয়েছে সব, ঠিক আছে, 25, 29। যেটা 3338 বললাম একটা, ওটাতে হুম এইখানে হ্যাঁ 757 and following order was passed. এই 45, Again, the petitioner filed another writ petition being WPA 9352 of 2024. 9352 of 2024. Alleging of non-consideration of representation dated 16th February 2024. Issued to the subdivisional officer, Katua subdivision, being respond number 9 therein. 44. Para. The principal contention of the petitioner is that despite there being finding of the Reed Court and the Court of Appeal that the aspect regarding encroachment is a matter to be decided by the civil court, the order has been passed by the impugned orders under challenge has been passed by the subdivisional officer, holding that there is encroachment. The measurement made by the revenue officer does not depict of any deviation so far as the site spaces of the construction is concerned. Hence, the impugned orders passed are palpably bad in law, since the orders passed in the writ petitions and in the appeal has not been complied with strictly. Mr. Swensu, learned advocate, appearing for the petitioner, submits that the orders passed in the writ court as well as by the appellate court records of deviation, if any, with regard to the site space. However, however, there is no such specific finding in the impugned orders regarding deviation in construction pertaining to the site spaces. Therefore, the impugned order is liable to be set aside. Learned advocate for the state in both the writ petitions indicates that the construction, this is in plot number 515018. The construction undertaken by the petitioner has exceeded on the northern, southern, eastern and western side. Which is depicted in the report of the revenue officer. Date of the report. Reported date of
In the third petition, page 55.
okay. 55.
55. Here, here, my lord, the term has been used as occupied, not the encroachment.
Occupied means encroachment.
55. It report dated 14 January 2025. একটু সেন্টেন্সটা বলে দাও আগে। हाँ, ठीक. Therefore, there is clear deviation from the sanctioned building plan. Both the single judge as well as division bench has opined that if there is any deviation from the sanction plan, the authority shall take steps in accordance with law. The impugned order has been passed after finding such deviation from the sanction plan and thus does not call for interference. Similar submission is also advanced by learned advocate representing respondent number 11. It is a fact that in the earlier round of litigation in WPA 3338 of 2023, this court observed that the findings of encroachment by block development officer and subdivisional officer can only serve as a supporting evidence in the title suit filed by the petitioner, being title suit number 44 of 2019. The final decision has to be taken by the civil court. However, the issue as to whether construction of respondent number 10 has been made strictly in accordance with the sanction plan and in accordance with rules will have to be decided by appropriate authorities at appropriate stages under section 23 of the West Bengal Panchayat Act 1973. In the appeal in MAT 757, the Honorable Division Bench observed that the learned single judge has rightly held that issue of encroachment has to be decided by the civil court in pending suit. However, the issue as regards construction having been raised by the appellant herein in deviation from the sanction plan has to be decided by the concerned Panchayat authority. Therefore, from the aforesaid orders, it manifests that in the event of any deviation from the sanction plan, the concerned authority, the appropriate authority, was to decide the aspect of deviation. Para. The impugned order under challenge dated 26 March 2025 records as follows. Page 71. From the aforesaid order, it is clear that there is a deviation in construction of building in question from the sanctioned building plan issued by the Gram Panchayat. The order of demolition has been passed after finding such deviation from the sanction plan. The earlier orders of the court also records that in case of any deviation, the authority shall take steps. Accordingly, this court does not find any infirmity in the order passed by the authority concerned for demolition. Hence, the writ petition falls short of merit. Both the writ petitions are dismissed. And sorry.
Of my submissions I have submitted already, my lord. First of all, my lord, the civil court, they have failed to prove the
ওখানে দিয়ে দাও, this in the civil court they have failed to prove any encroachment.
That demolition proceeding happening. Apart by landlord can have submitted.
No, that cannot be. They will take steps in accordance with law.
And my lord, another thing, my lord, submission was that the civil court, the suit before the civil court becomes infructuous if the SDO's orders is executed. That submission will be recorded.
You know, this order of the civil court becomes infructuous in the event the order of the subdivisional officer is executed. You know. Oh, no submission. যেটা যেটা পেয়েছি
Obliged.
both the writ petitions are taken up analogously. Next,
Item number 52,
52.
52, I am applying for the petition and motion.
Yes.
Ma'am,
On the
Computer service.
this for the state.
There, my lord. And my lord, the rest, all total 10 respondents are there, my lord. 4 and 5, my lord. Those are not delivered. 2 and 5 is insufficient address. 4 was refused to that. Very good service, my lord.
Affidavit of service filed on behalf of the petition is taken on record. Can 1 of 2025. This is an application for restoration of the writ petition. By recalling order dated 17th December 2024. Para. By order dated 17th December 2024, the writ petition has been dismissed for default. Ground, madam.
Paragraph can 1, paragraph number 2 and 4, my lord. The earlier advocate, my lord, this is a change brief, my lord. Earlier advocate, he did not came to court for his help, my lord.
Learned advocate for the petitioner. So and so learned advocate for the petitioner submits that on the date the matter was taken up, the learned advocate failed to appear, resulting in dismissal of the writ petition. She seeks for a restoration of the writ petition. Learned advocate for the state leaves the matter to the discretion of the court. Do you have anything to discretion of the court? Considering the averments made in the application, the submissions advanced on behalf of the petitioner, the caution is sufficient to restore the writ petition by recalling order of dismissal. Accordingly, the order dated 17th December 2024 is recalled. The writ petition being number WPA number 25762 of 2023 is restored to its original file and number. Any application was there? On file and number. Can 1 of 2025 stands disposed of? What was the stage?
My lord, the motion stage.
Motion stage. WPA they call list this matter under the heading motion.
Private respondent, the intimation must be given to the private respondents for service.
My lord. I have,
Petitioner is directed to serve
they all have.
copy of the writ petitions upon the private respondents. Copy of the writ petitions along with its annexure upon the private respondent file affidavit of service on the returnable date. List this matter after 2 weeks under the heading motion.
Item number 53.
My application for amendment. And number 1 is an amendment.
I'm appearing for respondent number 3. I have instruction to appear on behalf of the Pradhan, my lord.
Hmm. What is the amendment?
All other respondents has been served. Yes, the rest.
No, what is the amendment? Carry out.
Lord, the to lordship.
Application for addition of party, my lord, not amendment application.
Addition of party.
The liberty was granted by on order dated 17th December 2024 at page 8 of your lordship.
And we will make
And
formal
number
application including the Pradhan. Oh,
During the course of hearing, it has felt that the Pradhan must be added as a part. My lord, therefore, this application has been filed for adding as a party, Pradhan adding as a party response. That's the.
so Pradhan is here.
Yes, my lord. I have
What is your
instruction to appear on
submission?
behalf of- No, my lord. I have no objection, my lord. Kindly direct them to serve a copy and also
Can
direct
one
them
of
to amend the
2020
post title
affidavit
of
of service filed on behalf of the petition is taken on record. Can one of 2025. This is an application for amendment for adding Pradhan Nosipur Gram Panchayat, village Diara Police Station, Singhu, district Hooghly as a party respond number 4. Learned advocate for the applicant submits that upon liberty granted by this court on 17th December 2024, this application has been filed for impleading the Pradhan of the concerned Gram Panchayat in the present proceedings. He seeks for adding the Pradhan of the concerned Gram Panchayat as a party respond number 4. Learned advocate appearing for the Pradhan of the concerned Gram Panchayat leaves the matter to the discretion of the court or state. Who is for the state?
Appealing for the state lordship.
State. Both further. In view of the in view of the amendments made in the application and the submissions advanced on behalf of the petitioner, the Pradhan ki Gram Panchayat, Nosipur Gram Panchayat, village Dihara Police Station, Singhu, district Hooghly is added as a party respond number 4. এখানে উনি তো অ্যাড করে দেবে, ডিপার্টমেন্টে যাওয়ার কি দরকার আছে? হ্যাঁ, এখানে তো উনি অ্যাড করে দিতে পারবে না। লিভ দিয়ে দাও। Leave is granted to the learned advocate for the petitioner to implead respond number. Do it. Other parties has been served.
My lord, kindly direct them to serve a copy upon the Pradhan.
Writ petitioner, learned advocate for the petitioner is directed to serve a copy of the amended writ petition along with its annexures upon the added learned advocate for added respond number 4, Pradhan. It will appear under which heading? Motion. It is this matter under the heading motion after 1 week. In the meantime, you serve the copy.
Grateful to your lordship.
Can one of 2020
Granted to
add? Yes. Yes. Advocate on record. Who is advocate? Get the advocate on record. এটা কি অর্ডার সের আছে? অর্ডার সের এটা কি আছে? কোনটা আছে? দেখি ডাকো একবার তো কি অর্ডার সের আছে, নাহলে হিয়ারিং এ চলে রিটার্ন এর মোশন।
Orders.
Item number 54.
This one that I am appearing for on behalf of the authority concerned. 54.
Oh, served.
As per your lordship direction, I have served my lord. We have received it.
Okay.
54 করবে। But I have served. So your lordship kindly come. If you don't is case 3. Now, case 5. Same delivered case 5. 5 and page 9. They have received. And সব দিয়েছি সব
He's from Bankshal Court. Bankshal Court.
yes. So Arup Rai is Bankal Court, violation number 10,
Hmm.
Delta House. Ashutosh Singh. 5.
Blood Ashutosh Singh is here.
I am appearing.
Ashutosh Singh is here.
Lord, you served a notice upon my senior and me, my lord. On the last occasion, there were instructions that they would be removing the structure and they had only asked us to pray for time before your lord. Your lord was initially granting us 15 days. Thereafter, upon our prayer, it was extended to 4 days.
Where is Mr. Roy?
But he's on the way. He's coming. He's on his legs. On his way.
এটা কি pass over রাখুন তো। But the party says that there was no such wakalatnama or any communication was made. Then how could you submit before the court that you will demolish that structure?
There was an undertaking. We were engaged by an advocate called Suncharan Ghoti.
All will be coming.
When he
We have
saying
to
that
believe
he
the
is
learned advocate. He says that he is on the way.
Why you are so hurry?
But time, my lord.
Let him come. What he submitted, let us inquire because we are waiting for him. Why did he make so submissions before the court? একটু pass over রাখুন। Ask him to come. আরে returnable এ যান।
Item number 216.
One matter. Item number 236 appearing before your lordship today, which was fixed by your lordship by an order dated 10th of April 2025.
সব নেমে নেমে চলে যাচ্ছে।
Written before your lordship may not reach today because there are various other matters. So your lordship kindly fix the matter on Tuesday, subject to local sanction at the
কি
top.
হয়েছে দেখি? আর এইগুলো মেনশনিং করলে খুব
It
অসুবিধা
is
হয়েছে।
the order passed by law. Lordship fix it.
কি অর্ডার এটা? অসুবিধা সিনিয়ররা যদি মেনটেন না করে তাহলে তো আমরা কি করবো বলুন তো? সিনিয়রকে তো মান্যতা দেবো তাকে মাঝখান থেকে কেড়ে দিলে কি
Other
করে?
side.
পরে দেবো পরে। Afterwards, not now. It is যে আইটেম নাম্বারটা আছে ওটা দেখো কালকে দেখবো। What is the item number? 236. Okay. Tomorrow we'll see. চলো এখন 216 দেখো। 216.
216, I beg to appear for the petition.
216. কালকে দেখবেন।
এটা অর্ডার দেবো। Yes. You had to make your submissions
Yes.
with regard
Well,
to
before
back page.
I start, my lord, kindly don't take me amiss if I say, my lord. On the last occasion, I was running from code 18. My learned friend started submitting like this. Then on 14, the date was fixed. On 18, they supposed to come. They did not come. They took time. All these was placed before lordship. And I know him personally. He is quite junior in this profession. I have lapsed 23 years here. Perhaps more than 2-3 years he has not come here. He is making submission like this before a court of law, before lordship. That I was running from court number 18. 2.5 minutes I took from 18 to here. And he was submitting for lordship. No. On 14 they was fixed. They took time. This was being submitted by him, my lord. This was, my lord, this is not on the merit or not on the fact, but this type of situation must not go on. The new generation coming, The new generations are coming. They are of the new generations. If this is the attitude, now my lord, kindly visualize what will be in after 10 years. What will be the court after the 10 years?
চলো দেখি মেরিটে কি আছে।
Lord, I tender my unconditional apology if I've hurt you in any way, my lord. I was just
This is no question of heart, my lord. This is no question of heart. He submitted before your lordship that as if I have intentionally trying to delay the matter. As if, my lord, it is not my view, your lordship. I have appeared in so many matters before lordship. Never I have tried this. Never.
But my apologies to him, my lord.
No question of apology, but this must not go on. Lord, you on Lord,
Okay,
coming back to the Lord fact, Lord, Lord, your lordship was pleased to ask me to address me on
your friend will not leave you. Whether it is taken or not taken, but you have to wait for him. Sit down. Everybody is asking you to sit down. Mr. Bhattacharya also says so.
your lordship was pleased to ask
Whether
me-
back wages order be given or not.
Yes, that is the 2024 SCC online 9254.
Yes.
He relied on, my lord, two paragraphs, paragraph 8 and 9, if I am not wrong.
Yes.
Now kindly come to that, my lord. The alleged action of the petitioner are very serious. However, as has been held by the Honorable Apex Court that even if the services of a casual employee working as such of for a reasonable period of time is to be terminated on the ground of misconduct, the same has to be preceded by a proper inquiry which has to be afford adequate opportunity of hearing to the petitioner. A simple inquiry by a chosen few preceded by a so-caused and followed by placing the inquiry report before the governing body without seeking any further response from the petitioner is not sufficient compliance of principle of natural justice. Then, in view of para 9, in view of the above, the interest of justice, the impugned order of termination from service is set aside, and the respondent authorities are granted liberty to initiate a proper inquiry in accordance with law and conclude the same within a short time, preferably within a period of 12 weeks from the date. Then here, the learned court, Honorable Justice Sengupta was pleased to consider the concept of natural justice. As per his lordship's view, it has been violated. So, the question of back wages come in, as it has been violated. So, we are coming back to the petition itself. I have twofold submission on fact 1, and I beg to submit 2 judgments, my lord, on this aspect. Now, kindly come to page 22 of the writ petition. Issued by the PO and BDO, Ratwa to Malda on 14th of January 2022.
Hmm.
Have a lordship got it? My lord, may I please follow your lordship? 2 Masjidur Rahman petition are reference to memos which I relied on the last occasions. In reference to the above and observation from this end, lapses on your duty assigned for execution of this engineer scheme have been found. Now you are directed to so-called the causes why legal action shall not be taken against you within 7 days from the date of receipt of this letter. This is the so-called we issued. Now, my lord, his reply in the very next page, page 23. To PO and BDO Ratwa, reply to so-called. This is reply to so-called. BLE memo number such and such dated 14th of January 2022. Respected sir, বিনীতি নিবেদন এই যে উক্ত পত্রমূলে MG রেগার 33টি প্রেয়ার ব্লকের স্কিম বেনিয়মের কথা বলা হয়েছে তার উত্তরগুলি নিম্নরূপ। 1, উক্ত পত্রমূলের স্কিমগুলো 2018-19 আর্থিক বর্ষের অ্যানুয়াল অ্যাকশন প্ল্যানে আছে। অ্যানুয়াল অ্যাকশন প্ল্যানের কপি দেখে স্কিমগুলো এন্ট্রি করেছিলাম, যার কপি সঙ্গে দেওয়া হলো। 2, এর ফলে যখন যেমন 4-এর ক পেয়েছি তা দেখে ডিমান্ড করেছি, যার কপি সঙ্গে দেওয়া হলো। সুতরাং দিস ওয়াজ আমরা, দেন রাইট ইট, স্টাক ইট ডাউন, দেন আমি। যদি অনিচ্ছাকৃত ভুল করে থাকি তাহলে মার্জনা করার জন্য আবেদন জানাই। Pausing here for a moment. He said that if I have done anything wrong, well, putting question to myself, if I have not done anything wrong, then I should not write, or I ought not write that I have done anything wrong. If I have done anything wrong, kindly excuse me for that. If not, I am conscious about the fact that I have done anything wrong. The question, the fact, the language here suggests that something has been done by him which he tried to suppress, or now by this presented petition he is trying to cover up that situation. Now, my lord, the question of natural justice, your lordship, what fallen from your lordship, my lord. Now, may I place judgment, my lord, to judgment support? চব্বিশটা কই? 22, ঠিক আছে। হ্যাঁ, একটু চলবে, একটু আমি কি করে বলবো স্যার, একটু তো চলবো স্যার। My lord, may I place judgment? 2022 SCC online Cal 523. My lord, kindly come to paragraph number 10 onward.
Yes.
The impromptu letter of discontinuation was issued more than a month after the petitioner was put on notice by the VC. The petitioner was asked to discontinue from the position, and all the, my lord, the facts have been elaborated here. Now, the word fire, hire and fire cry a sense that an inherent and abrupt injustice underlined in the imputation is one summary dismissal without opportunity of meaningful say in the decision of dismissal. There are also several sectors where the persons are employed under the condition of a summary dismissal on the happening of certain events. In other spheres, these conditions may be seen as necessary for maintaining disciplinary standards and competence levels of employees. This was recognized by the Supreme Court in the, some judgment has been referred there to 2001 9 SCC 31. I am not relying on that, my lord. On an Supreme Court held that the employer is entitled to assess the stability of an appointee. He has a right to terminate the service if the service are found unsatisfactory. But this honorable court was pleased to hold these lines and pleased to pass these lines after going through the concept of the natural justice. Now, in the central, my lord, the next paragraph, paragraph 13, my lord. Kindly come to paragraph 13. In the Central Inland Water Transport Corporation versus Bojanath Ganguly, the Supreme Court dealt with the reasonableness of clause 9(1) of the Central Such Act. This clause provides for termination of appeal rules framed by the corporation. This clause provides termination the service permanent employee on the ground that the service may no longer be required in the interest of company and without assigning any reason. The Supreme Court evocatedly described the said clause as a higher Henry 8th clause, my lord, as was conferring absolute unguided power upon the corporation. Now, my lord, kindly come to paragraph, next paragraph 14. It is important to note that both Bojanath and Dipali, these judgments were cited in this dealt with the instances where due process was given a short shift by the employee. The decisions also dealt with permanent employees who had served the respective companies for long period of time. In the fact of the present case, although a letter of appointment does not indicate whether the petitioner was taken on probation the appointment does not indicate probation. The admitted fact is that the petitioner had just completed 4 months in service. But pausing here for a moment, kindly consider in this particular case where I am reading the judgment passed by this honorable court, the petitioner was even not a permanent employee. He was a contractual employee where this has happened, and the question of natural justice had this honorable court had considered after considering this order has been passed. Well, now I beg to rely on a judgment passed on 2020, volume 18 SCC 752. এটা মাইলট কেটে দেবেন তো well, kindly come to paragraph 7 of the judgment. It's on the 3rd page, my lord. Have you not got it, my lord? It is equally well settled that the principle of natural justice must not be stretched too far and it is the connection, reference, and may be made to the decisions of this court in Sohanlal Gupta versus Asadi Gupta, and all the judgment has been there, my lord. This court held that principle of natural justice are not inflexible and may differ in different circumstances. Rules of natural justice cannot remain same applying to all conditions. In the Board of Mining versus the Chief Inspector Mines versus Ramji, the court observed that the natural justice is no unruly horse, no lurking landmine, nor a judicial cure all. My lord, in the interim paragraph, the last violation regarded as a lethal objection is that the board did not inquire of the respondent independently of the one done by the regional inspector, assuming is to be necessary. Here the respondent has, in the form of an appeal against the report of the regional inspector, sent the explanation to the chairman. Well, here the circumstance has been described where the honorable court has come to the conclusion that natural justice to be dealt with in a fashion that it's not there is no straight jacket formula to input that yes, natural justice can be put here, cannot be put here. There are circumstances, there are facts and circumstances where it will be put. But now, Lord, I beg to rely on 1997 volume 1 SCC page 444.
Yes.
Sixth page from last, I have not marked it, is paragraph number 48. Internal page will be 461. May I read for Lordship?
Wait.
May it also be stated that it is well settled that requirements of natural justice can be molded in such a way as to take care of two basic facets of the principle. One, to make known of the nature of acquisition, and two, to give opportunity to state the case. State the case. As accepted by this court in Hiranath Mishra, Principal Rajendranath Medical College, and in Subhash Chandra case, it has been even held that no hearing is required to be given to the candidates before cancelling the examination, where mass copying was indulged. If a case for the same was otherwise made out, present it is also a case of large-scale out-of-turn alterments, and also the principles no hearing at all might have been given, but we did not go to that extent and gave an personal hearing to many among those who choose to appear pursuant to the notice published in the newspaper, which they with the facts in the employees concerned were. Then the next paragraph 49. In the why I rely on page paragraph 48. There the honorable court was pleased to hold that even if they say that our examination has been cancelled without giving an opportunity to us, the court went on saying that no, if we find that there is no ground made and there is no question of asking you to be appear here, we can suo motu cancel it. There is no question of violation of natural justice, or you cannot urge. Then I have a point of audio alteram partem that has been thrown out. Now, my lord, the natural justice, paragraph 49. The natural justice is, after all, no unruly horse, no lurking landmine, as characteristically stated by the Justice V.R. Krishna Iyer in Chairman versus such and such versus Ramji, in unnatural expansion without reference to these realities can be expressing as observed by the learned judge. It is also
But these
what,
these
my lord?
facts are not similar
My lord,
to the case.
facts.
You have a guideline that is at page 26.
আপনি kindly চলে যান।
So nothing.
সাবমিটিং তখন থেকে পড়ে যাচ্ছে। We have to learn from this, from the seniors. What shameful for us.
What is
Shameful for us.
no? These facts are
So
dissimilar.
kindly allow me to retire from the brief. But this cannot go on. From the behind, it is being said that তখন থেকে পড়ে যাচ্ছে। Cannot go on this.
Anyway, the facts in
facts are
1997 case are dissimilar.
Yes.
In the present fact, there is a guideline at page 26.
My lord.
The principal case of the petition is that guideline has not been followed.
But I say, my lord, guideline was followed, but not in toto.
Yes.
Clause
Then also
5
there is it.
was not.
Yes.
My lord, on the last occasion, I intend to rely on a my lord concept.
Hmm.
My lord, kindly consider. There is a concept, my lord, if Harvis leges non est residendum, then all should be read as a whole. I wanted to urge before your lordship, but due to some paucity of time, that cannot be. That everything, every guideline, every notification, every order, every judgment, every petition, everything to be read as a whole, not as a part and parcel to be cannot be copied and pasted here and there. Well, here also 1 to 5, 1 to 7, these were the guidelines. I admitted on the last occasion also, yes, I have failed to follow the clause 5, but that does not mean, my lord, ultimately subject to my consideration by your lordship. My respectful submission is this, my lord, that does not say or allow the petitioner to say that the entire proceeding, the entire termination is void or invalid or void ab initio. Because I have followed the things, I have issued the letter of so cause, you replied to this. Now your reply was not satisfactory to me. You have never went to that no, it's my satisfactory, you come here, you do this, all this were not done. And Lord, that legal maxim and the application of legal maxim says that every petition and every notification issued by any of the authority or a petition filed before a court of law or a judgment, everything to be read as a whole, not a part and parcel to be picked and chosen. Lord, banking on that, I beg to submit that termination notification issued by the authority lacks a point, that the point number 5 or rather the clause number 5 was not taken care of. Rather than this, Lord, everything was taken care of. So, Lord, that will not give a German that the entire thing will go by, to be given a go by. So last, Lord, kindly allow me to submit the 1977 judgment, Lord, banking upon which the everything has been passed. 1977 2 SCC 256. এটা মাইলট করে দেবেন। paragraph number 13, it's internal page 262. The body 13 is in the bottom, Millard. The last violation regarded as a lethal objection is that the board did not inquire of the respondent independently of one done by the regional inspector, assuming it to be necessary. Here the respondent has, in the form of appeal against the report of the regional inspector, sent the explanation to the chairman board of the board. He has thus been heard and compliance with regulation 26. In circumstances complete, natural justice is no unruly horse, no lurking landmine, nor a judicial cure-all. If fairness is shown by the decision maker to the man preceded against the form, feature, and the fundamentals of such essential processual property being conditioned by the facts and circumstances of each situation on breach of natural justice can be complained of. Unnatural expansion of natural justice without reference of the administrative realities and other factors of a given case can be expressing. We can neither be final or fanatical, but should be flexible yet firm in its jurisdiction. No man
Yes.
shall be hit below the belt. That is the consensus of the matter. Lord, banking upon which the 1997 and the 2020 order has been passed and by the Honorable Supreme Court, and 2022 what I relied upon, my Lord, by our also High Court also passed. On the last occasion, your Lordship was pleased to direct me to address your Lordship on the point of back wages, that is 2024, passed by Justice Sengupta. Justice Sengupta was pleased to pass the order banking upon the situation that natural justice has been violated. As the natural justice has been violated, then the entire situation comes back to a zero. If the natural justice is violated, then the entire proceeding, the termination is terminated as to be illegal or invalid. And if the termination is lifted on that day, very day when the termination was imposed upon the petitioner, or the case may be that person, he is a fresh person without having any termination on stigma or a patch on his career. And from that day, he is entitled to have his back wages. Well, here, the question of natural justice to be put in a fashion that we have to consider the two aspects. One, whether he has been given an opportunity or not. Two, whether we have issued or taken care of that or not. But I very much, even now, I will admit that the guideline for termination, the clause 5 therein has been did not taken care of. Rather, we cannot say that I have violated, but I have not taken care of that, Willard. And only that much the situation is. And if my lord, that is the situation, that non-following of a clause make the termination or the situation complete go by, my lord, that is perhaps not the law of the land, my lord. The last, my lord, I beg to submit, my lord, what the natural justice is, my lord. Kindly consider. My lord, কেটে দেবেন তো একটু। Page 64, my lord, point number 122. Halsbury Laws of England, my lord. A power analogous to that of restraining by means of the order of prohibition and certiorari and excess of jurisdiction by the reason or body exercising judicial or quasi-judicial functions is the power to restrain or to quash the decision of those person or bodies if they fail to observe that they have been called the rules of natural justice. An order of prohibition may be granted to restrain, and an order of certiorari may be granted to bring up and quash the decision of a person or body exercising judicial or quasi-judicial functions if he or it fails its duty to act in good faith. My lord, kindly mark here, my lord, if he fails to act his duty to act in good faith and to listen fairly to both sides and to give a fair opportunity to the parties in the controversy, adequately present their case and to correct the contradict and any relevant statement prejudicial to their views. It is not the case that the procedure or every tribunal must be same, or it must be the same. My lord, next page, my lord, it must be the same at the top, page 66. Same as that followed in the quote stricto sensu. When the sorry, my lord, when the statute under which a tribunal is set up permits it to reach its decision on its own knowledge and without any evidence, even if it has observed the formalities prescribed by the statute and has not excluded any evidence tendered to it, its decision cannot be impugned. Where, however, a tribunal which has power to make such inquiry as it thinks fit decides a case on a matter of fact discovered by the tribunal itself, on inspecting the premises in question, it will be a breach of natural justice if does not inform the parties, give them a chance of dealing with it. If a tribunal receives from a third party a document relevant to the subject matter, a proceeding, it should be both parties an opportunity of commenting on it. A decision of an inferior tribunal will be quashed. My lord, that is not the case. My lord, just for the cost of repeating, my lord, kindly excuse me. If I replace the, my lord, repeat the point number I here.
Yes.
Point number I, page 66, my lord. At the cost of repetition, my lord, I have to submit this, my lord, once again. If a tribunal receives from a third party a document relating to the subject matter of the proceeding, it should give both parties an opportunity of commenting on that, and in violation of this will attract to natural justice. Why I repeat this, my lord, we issued a letter of show cause. I placed it before your lordship. The reply to show cause was also placed before your lordship. The reply to show cause was so non-speaking, your lordship I can apply your lordship that this cannot be termed even as a reply to show cause. His nomenclature is reply to show cause, and he said, if I am wrong in any point, kindly excuse me. This is the reply to show cause. Lord,
Okay.
I'm putting question to myself, my lord, can it be termed as a reply to show cause, or can it, the nomenclature of a letter and the body of the letter be different, and it will be treated as per the nomenclature only? The lacuna of the petitioner in dealing with the case, dealing with his termination, lies here. And that HON'BLE clearly says, my lord, if it is not guided, if it is not taken into account, then the natural justice comes. If the natural justice comes, then the question of Justice Sengupta comes, my lord. The order of 2024 comes. My lord, this is my respectful submission.
Kindly have the judgment relied upon by the state reported in 2019 SCC Online Cal 9241, which is flag 1, I suppose, my lord.
Yes.
As it very rightly fell from your lordship on the previous occasion, the facts of the case are different from the one we are considering at present, my lord. It is a case, my lord, in which challenge was thrown to an engagement of a successful candidate by an unsuccessful candidate. There was no employer-employee relationship. He participated in an examination by virtue of a notification which goes against him. There was no right of his that was infringed at the first place. He was aggrieved by the appointment of somebody else. And my lord, even that, my lord, your lordship also pointed out that even so, my lord, it was held in paragraph, my lord, paragraph 10, my lord, if your lordships have, my lord, of that judgment, that all these things will not come into account if there is any palpable illegality or perversity or arbitrariness or malafide exercise of power or authority. So, my lord, even if I discount all the above submissions with respect to dissimilarity of facts, my lord, on this sole ground itself, this judgment is in my favor by saying that all these things will not come into play if there is this. So, my lord, I say, my lord, with all due respect, my lord, that these are, since I harp on the point that these are present in the impugned order, my lord, so therefore, my lord, the applicability of the judgment binds the respondents to apply this in the facts of the present case, my lord. That's number one, my lord. Kindly take the second judgment, my lord, that has been relied upon, track 2, my lord, which is, my lord, 2007 11 SCC 681, my lord. My lord, the issue, my lordship have it, my lord. Flag 2, my lord. My lord, the issue in before the Honorable Supreme Court in this judgment, my lord, was with regard to regularization of Anganwadi worker. My lord, the petitioner, my lord, is not seeking any regularization whatsoever before your lordships, my lord. He is aggrieved by order of termination, my lord. Petitioner is a contractual employee. Even if your lordships reimpose or reinstated him, my lord, the state will be at liberty to take action against me in terms of the guidelines applicable to the contractual employee. The contractual employee cannot, my lord, make a case for regularization before your lordship, and he is not, my lord. Lord, yeah, this is as far as, my lord, the flag 2 2007-11 SCC 681 is concerned. I will kindly take the third case that has been cited, my lord. It is, my lord, flag 4, my lord, 2020. Flag 4, my lord, of that bunch that has been handed up to your lordship by the state, my lord. My lord, 20. My lord, the next judgment cited by state, my lord, is flag 4, reported in 2023 SCC online Cal 1032, my lord. Flag 4, my lord. My lord, this judgment was cited to buttress the proposition, my lord, that if the petitioner has belatedly approached the writ court, my lord, the writ court should not be condoning his delay, my lord. My lord, with utmost humility at my command, I submit, my lord, to your lordship. The petitioner was terminated in 2022. Immediately in 2022 itself, the petitioner preferred a writ petition, my lord. The order at page 30 will show, my lord, the petitioner was frustrated that his matter was not taken up. He was compelled to change his learned advocate on record. Upon a change brief being given, my lord, this petition with the leave of the Honorable Court was withdrawn, my lord, and immediately, my lord, within 7 days after withdrawal, my lord, this writ petition was filed. So, my lord, there was no question of delay or latches on the part of the petitioner, my lord. Petitioner was ever vigilant about his case, about his precarious circumstances, my lord.
Earlier order has been annexed.
Page 30, my lord.
Page
30. So, my lord, it is not a case where my lord, this court took up the matter and dismissed for default. Petitioner was not vigilant or took up the case. There was any order to that effect. No order was passed for last 2 years, my lord. Petitioner cannot be faulted, my lord, if his matter is not taken up, my lord. That is with respect to flag 4, my lord, 2023 SEC online Cal 1032. Lastly, my lord, on the previous occasion, 2019 SCC, my lord, was cited, my lord. My lord, that is flag 5. My lord, 19 SCC 9, my lord. This is to put forward the proposition, my lord, everything has to be read as a whole, my lord. I say, my lord, yes, it has to be read as a whole, and on reading of the whole only, my lord, lordship will come to the conclusion that, my lord, irresistible conclusion, my lord, that the memo has not been followed, at all has not been followed, my lord. If your lordship read it as a whole, my lord. So, my lord, I am with this proposition, my lord, everything has to be read as a whole. Now, my lord, these are all the judgment that was referred on the previous occasion. Now, my lord, with regard to today's judgment that has been cited. Well, the first judgment today that has been cited, my lord, is 2022 SCC online cal 523, my lord. My lord, to on the question of my lord, I don't remember the question that was thought to be answered by this judgment, but anyway, paragraph 13 was thought to be relied upon, my lord. From what I could.
No, you have not followed his argument. He says that Justice Sengupta has passed an order for entitlement of back wages, holding that there was a violation of principles of natural justice. He says that by this citing this judgment, that there is the definition of natural justice violation has been given, and in the facts and circumstances of the case, there is no violation of principles of natural justice, since the show cause was given, saying that there was some lapses in duty so far as Manrega is concerned, and you have given a reply. He concedes that clause 5 ought to have been added to. That has not been. So he says that there is no such overall, there is no such violation of principles of natural justice. So clause 5, from clause 5, the authority will take recourse to whatever article of charges will be supplied, and thereafter departmental proceedings will be initiated, whatever in the G is concerned. That is his submission.
My lord, kindly have, my lord. Well, I'm grateful, my lord, for explaining.
Yes, yes.
My lord. Kindly take paragraph 13 that my learned senior friend relied upon, my lord.
19.
My lord, 2022 SCC online cal 523, the first judgment that was handed up to your lordships today, my lord. Paragraph 13 was relied upon, my lord, if I'm not mistaken, my lord. My lord, which, my lord, if I have understood the placing of that paragraph correctly, my lord, there, my lord, your lordship will find, my lord, it was something in my favor, because the clause which says service may no longer termination of an employee on the ground is that his service is no longer be required, my lord, was castigated by the court, my lord, by saying that it is a Henry VIII clause, my lord, which gives unbinded power to the authorities, my lord, which, my lord, in my respectful submission is something in our favor, my lord. That this way cannot, a termination cannot be done in this way, my lord. My lord, that is with respect to with 22 SCC cal 523, second judgment he has relied upon, my lord. 2020 18 SCC 752, my lord. Paragraph 7, my lord.
Yes.
The 20, my lord, 18 SCC 752. My lord, paragraph 7 was relied upon, my lord.
Yes.
My lord, I say to paragraph 7, my lord, that yes, there could have been a case, like your lordship knows, my lord, in article 311, if I'm not mistaken, my lord, with regard to permanent employee who are in civil post, my lord, with regard to their disciplinary proceeding, my lord, there can be an occasion in which national security is involved, my lord, that the president or the governor, as the case may be, honorable president or honorable governor may, my lord, if the case so arises, may dismiss an employee, my lord. And in Jammu and Kashmir, often this is being done, my lord, by invoking the principle of, my lord, sovereign state interest, public interest, my lord, larger public interest, my lord. I say, my lord, if the case in hand is of such nature, my lord, nothing would have prevented the respondent authorities, my lord, to say so in the order of termination, that for such and such reason, his article of charges is not required to be given to him. He may be terminated forthwith. My lord, that would have at least let the employee know on what basis he has been terminated, my lord. Today, the employee is totally in dark. Why he has been terminated? So, my lord, that is with regard to 2020 18 SCC 752, my lord. Now, my lord, the next judge.
Yes.
The next judgment that was relied upon, my lord, 1997 1 SCC 444, my lord. My lord, if this is a case, if I have understood the facts of the case correctly, my lord, this is a case where, my lord, an examination, I don't know whether it's for employment or for any other competitive examination, which was cancelled, my lord. The aspirant, my lord, they comes to the honorable court challenging that cancellation. It was urged, most probably on behalf of them, my lord, that we have not been heard, so the cancellation is bad. Honorable Supreme Court says that is not the case. Every individual aspirant cannot be given a individual hearing. Everything is public domain for everyone to know, my lord. I say, only say, my lord, this, that, my lord, if an examination is cancelled for each and everybody, and a fresh examination is conducted, nobody can be said to be prejudiced, my lord. Everybody has an equal right of participation in the next round of examination that is to be conducted, my lord. No,
But then the person who has qualified,
my lord, this is an even, my lord, even somebody's name is there in the panel. Let's take
suppose a person has qualified the examination. Now he does not intend to appear in the re-examination.
my lord,
That is right.
let's take like extreme case. Somebody's name is in the panel, my lord.
Hmm.
He is successful, he is empaneled candidate. My lord, subject to correction, my lord, even an empaneled candidate does not have a right to be selected, my lord. He is only have a right to be considered in terms of merit. My lord, his rights ends there, my lord. My lord, he cannot.
No, you cannot say that re-examination is not prejudice to cause any prejudice to either of the parties. It can be cause prejudice to the party who has. Suppose a person who has appeared in the examination, he has topped the. Now a re-examination order is passed. Is it not prejudicial to the interest of that person?
My lord,
Panel, you rightly pointed out, panel does not given right to have a service.
Yes, your lordship is correct. He will be prejudiced. But then, my lord, will your lordship issue a mandamus to the state by saying that you will not cancel, you will appoint him because he has stopped? That is the question.
No, that is separate. Service matter, that is separate. But so far as this is concerned, actually might be different, but prejudice is caused to either.
I bow down.
Next.
My lord, next, my lord, Halsbury Law of England. You know which edition, my lord, was cited, my lord. I am too junior in the profession to say anything on Halsbury. I will only say, my lord, principle of natural justice is something that is to be assessed on case-to-case basis, my lord. Here, there is a, I say, my lord, just to be out of track for a moment, this petition number is 14724, my lord.
Which one?
This petition that your lordship is considering?
Yes.
14274, my lord. Incidentally, my lord, on 23rd of April, civil appeal number 1714724 of 2024 came up before the Honorable Supreme Court, in which an Honorable Division Bench presided over by Honorable Justice Dipankar Datta, sitting along with my Lord Justice Prashant Kumar Mishra, had the occasion to consider the dismissal of an employee who was a Panchayat employee, he was an engineer. But the facts of the case very interesting. Firstly, my lord, he was without following the rules, he was dismissed. He come up before the tribunal. Tribunal sets aside the dismissal order, ask the department to reconsider. Again, they breach the procedure. Again, the employee comes. The tribunal reinstates him with all back wages. The state prefers a writ application. Writ fails. The state prefer an SLP. That SLP was disposed of by dismissing the state's appeal by holding that even if the complainant is not allowed to submit the document, cannot be proved by itself. The complainant who has filed the complaint, he has to be called and given an opportunity to be cross-examined by the person concerned to establish the complaint. So, my lord, under such circumstance, such is the law, my lord. Of course, that is for a permanent employee. Today, my lord, if your lordship have page 26, the initial paragraph itself says, my lord, why this guideline had to be formulated at the first.
You'll see that you have indicated in the first. That is all?
First paragraph.
Just one thing, not reply to reply. He has not responded to the Ramji judgment. That is the passed by Justice V.R. Krishna. He has responded to that. Not responded to that.
Okay.
Yes, Justice Krishna 1977.
Or Mr. Jayanto Shamantul, an advocate for the state, who concludes his argument. Replies are also being made by learned advocate representing the petitioner. It aage patiye din to. This matter. Kalke kor do. কালকে for orders এ দেবো কালকে Thursday for orders
Just one thing before I forget,
tomorrow.
my lord. My lord, I handed up one judgment, a copy of which I could not give on the first occasion. My learned senior friend was not there in the second occasion when I handed up the judgment, my lord. If your lordship just kindly mark the judgment, my lord, 38.5 is the relevant paragraph which I relied upon. A Supreme Court judgment, my lord, if your lordship wants the citation in
2008.
2013 judgment, my lord. The judgment citation, my lord.
Jaggo,
Jaggo, my lord.
para 14.
No, my lord, 2013, 324, paragraph 38.5, my lord. Another judgment I handed up, my lord. Jaggo, I handed up the copy. Another 2013, 10, 324, my lord. I handed up on the second day.
What is the name of the party?
My lord, name of the party is Dipali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya, D.Ed and others. I hope my lord, senior friend has taken a note of it, my lord.
No.
Your lordships opened up your lordship's iPad to see this judgment, my lord, because I wrongly submitted that it contains 350 pages, which later turns out to be only 35 pages and odd. But therefore, my lord,
The name, it is not here.
I handed up this judgment, my lord. 38.5, my lord.
2013. Dipali, yes.
Yes, my lord. Kindly marks, my lord. 38.5 is a paragraph.
38.5,
my lord. 38.5. I relied upon with regard to backwards.
कल के tomorrow for orders.
পরোটা কখন খাচ্ছে সকালে
হ্যাঁ এটা এর মধ্যে রেখে দিন
Lord, may I get back the book?
Yes. Give this page. Give a photocopy of this
I
page
will, I will.
tomorrow.
Certainly I will.
এটা দিয়ে দিন
Otherwise,
to
the
some-
lordship can keep
No, you take it. Give a
the
photocopy
lordship can
tomorrow at
keep
the time of
it
dictation.
today and tomorrow so that
Tomorrow.
no, no,
Give.
just for
Thank you. Yes.
This one is mine one. Mr. Mahato, Mr. Mahato is other side.
It will not be. Let it be fixed on Friday.
And Mr. Roy,
Yes.
you were there on the last date.
No.
Who made submissions that the respondent will undertake the demolish the structure?
Mr. Rai was engaged by Mr. Sancharan Ghotok. He had provided the necessary instructions, my lord. I was there in the court. He was in some other court. My submissions were made on that effect. However, the only difficulty was there was no wakalatnama handed over to her. Thereafter, my lord, a new set of advocates have been
So
engaged.
where is he? The learned advocate who has directed Mr. Roy to appear before this court and submit.
That's not here.
So where is Mr. Roy? You are Mr. Roy? No, you didn't appear on that.
He was in court. I also appeared with him. My lord.
So who submitted?
I submitted.
Without there being any wakalatnama, how do you take this responsibility of submitting on behalf of person?
We are given the impression that it would be supplied to it by the end of the day. Thereafter, a new set of advocates have been engaged. We have come to know.
The difficulty is for 2 days the matter is
I
getting
apologize.
adjourned only to find out who is Mr. Arup Kumar Roy who has made such submissions. Mr. He submits that there was no such connection between the party and the advocate.
Only after the letter was received by us did we come to know that this was the misunderstanding. We have come here. That is the issue.
Tomorrow you remain present.
Let it be fixed on Friday.
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 Can take Friday rakho?
10:30, my lord.
Huh?
Friday 10:30.
No, for orders no. Can take hearing rakho? You be present on the date of hearing. Should I record an order?
Should be there. 10:30 হলে
or you'll
করবে।
remain present because your presence is very much necessary since he has taken out an application for recall of that order on the ground that Mr. Roy was never appointed by the client to make such submissions.
তাহলে ডাইরেকশন মে প্লিজ গিভেন 10:30 at on Friday. নিয়ে নিন।
টপি থাকবে তো সেকেন্ড মে অ্যাপ্লিকেশন রাখবে সেকেন্ড মে
My lord, in this matter, my lord, item number 54, in this matter, I am appealing on behalf of the state, my lord. On the last occasion, the order passed, my lord, here.
Record and order.
kindly
আসুন আসুন আসুন
My lord, one submission, kindly, my lord. On the last order, my lord, Mr. Lalit Kumar
আসুন
Mahata.
আসুন ওই অ্যাপ্লিকেশন এটা where is it? Affidavit of service filed on behalf of you have filed it is taken on record. Mr. What is your name, sir? Your name, sir? Mr. Ashutosh Singh, learned advocate, submits that the previous submissions advanced by Mr. Arup Kumar Roy was made on the assumption that the Wokalatnama of the respondent numbers, yes, Miss 9 to 12, will be filed in the course of the day. Learned advocate Mr. Ashutosh Singh is directed to remain present on the adjourned date. Release this matter on 2nd May. Friday, 2nd May, madam.
Friday at 10:30 মিলাট 10:30
10:30, then what will happen to the POXO bill file?
as a matter of next day
On
next
2
day
p.m. Application.
they are coming.
That's
My lord, one submission, my lord, kindly, in this matter, my lord, on the last order, there is a mistake, my lord. The name of the state advocates has been mistakenly recorded as Lalit Mohan Monthal. He is present in the court.
inaberrant typographical error script into order dated
My lord, 22nd April 2025, my lord.
22nd April 2025, recording the name of Mr. Lolit Mohan Mahata
And Rudranil De, my lord.
and Rudranil De on behalf of the state instead of
Hemanto Kumar Das, my lord, and
Hemanto Kumar Das and yes,
Komalindu Ghosh, my lord.
Kamalindu Ghosh. Let the names of Mr. Hemanto Kumar Das and Kamalindu Ghosh be read in the aforesaid order. The above order is modified to the above section. No other, the other portions already remain on.
Is present 217. 217 is mine.
But 217 is it's to be released because it relates to Madhyamik Shiksha Kendra and it goes to my Lord Justice Shogata Bhattacharya. There is specific determination for Madhyamik Shiksha
No.
Kendra.
It will be released.
Yes, my lord. 217 that is to be released.
So, it is my matter. How it will be released?
Kindly have a look, my lord. It's Madhyamik Shiksha Kendra matter. And court number 18, Justice Shogata Bhattacharya has the specific determination to take up Madhyamik Shiksha Kendra matter.
It's my lord, the Madhyamik Shiksha
What is your item number?
217.
He says that 217 is the
Yes, 217 I am for the respondent number 9.
Mahato is judge for the state respondent.
My lord, I am for the state.
Third time, twice it was heard by the bench who has taken determination of panchayat. And so this matter is come before your lordship. It was before the Justice Kapoor, then it will come to your lordship. How it will go to other bench?
কি দিচ্ছেন
17.
No, 217 is a panchayat matter, group 5.
It has been written as Group 5. The subject matter is Madhyamik Shiksha Kendra, which is an education institution. And my lord Justice Shogata Bhattacharya has specific determination over Madhyamik Shiksha Kendra matter. Can you look who is the respondent number 10?
Can't be, it is your lordship determination. Because
If
there is a
someone
panchayat-
written wrong thing over the my lord presentation form that cannot confer jurisdiction and not determination.
Correct.
my lord, twice.
Kindly have a look to the my lord monthly
Order
list.
has been passed in the writ petition, as I find.
Yes, no order has been passed.
No. That you also know.
No, no,
Kindly have a look the monthly list.
That twice the matter was heard by this.
It was heard means these subject matter is hard litigation. Twice it was heard before the bench.
At that point of time, this institution was panchayat. Since
Okay.
2020, there is a change. That's why the determination has been changed.
change, my lord, no change. Kindly
Tomorrow,
take-
tomorrow. Hey, Google. Mr. Jahan, please come
Yes, well, I shall be. I shall be.
tomorrow.
Yes, well.
The subject matter of challenge is the order of the Assistant Secretary, School Education Department.
As you lordship,
Yes. Ultimately,
item number 54, as your
Subject
lordship
matter of challenge.
fix the matter on second, lordship. Instead of 2, can it be on 3?
No. Please come on second.
Top, my lord, tomorrow top.
Tomorrow it will come up top. Second.
Yes.
My lord, there should be punishment of Mr. my senior, Mr. Ghosh, because he has kept me waiting for more than 1 hour.
Buy him a coffee, a cup of coffee and other things.